Welcome to the NC Injury Rights Podcast.
Welcome to the North Carolina Injury Rights Podcast with Mehta and McConnell, where we break down workers' compensation issues for North Carolina workers who've been injured on the job. Viral and Jason are co-founders of Mehta and McConnell, PLLC, a Charlotte-based law firm focused on representing injured workers across the state. Both began their careers representing employers and insurance companies, and now they use that insider experience to help injured workers understand how the system actually works. I'm Evan Mack, and in the first episode, we're starting with what injured workers need to do in the first 24 hours after a workplace accident and why those early decisions matter so much. Gentlemen, welcome.
Hi. Thank you, Evan.
All right, guys, before we get started, into the first 24 hours, can you share a bit about your backgrounds and how each of you ended up focusing on your practice and representing injured workers in North Carolina? I guess, Viral, we'll start with you.
Yes, Evan. I started off, like you said, as a defense attorney for about a decade at a large regional defense firm. And then I, in early 2020, started representing injured workers. I found that representing injured workers to more closely align with what I want to do for a career, and what my vocational interests were. And I've really enjoyed helping injured workers get the benefits they deserve, counseling them through the workers' compensation process, which in North Carolina is a unique process. A lot of lawyers don't know about workers' compensation, so you really want to hire an attorney who specializes in workers' compensation. And what you'll learn about our law firm is both Jason and I are North Carolina State Bar board certified specialists in workers' compensation law.
What about you, Jason?
Pretty similar, Evan. I've been practicing law now in North Carolina for about 25 years. For the first 20 or so years of my practice, I was representing insurance companies and employers. And just got to the point where I wasn't really feeling fulfilled doing that. And thought I could be of more service by helping injured workers and people who are unfamiliar with the workers' compensation system. As Viral indicated, it's, a lot of people have some experience with some areas of the law. Workers' compensation is not one that folks generally have a lot of experience with. So felt like I could, through Mehta and McConnell, really help people navigate the system, get the benefits they're entitled to, and really counsel them through the process.
With that being said, in your work, what tends to be the biggest mistake injured workers make in the first 24 hours after an accident?
Well, this will be a theme that we'll probably discuss in a lot of our podcasts. North Carolina is somewhat unique in that an injury on the job site alone does not constitute a compensable workers' compensation claim. There has to be an accident, and there is a standard for what constitutes an accident in North Carolina. And fortunately, it's a fairly lenient standard. However, the injured worker bears the burden of proving by the preponderance of the evidence that they did sustain an injury as a result of an accident. Oftentimes, what we see in our practice is injured workers in those first 24 hours. Usually you don't have an attorney in those first 24 hours. They tend to put something in writing or give a recorded statement where they do not describe an accident. And that oftentimes is going to be a huge obstacle to overcome in their case. Similarly, the injured worker will go to a doctor, and when the medical provider asks, "How did you get hurt?" they won't mention the accident. It's not that there wasn't an accident. It's just the injured worker didn't think to mention that accident. But now it is forever memorialized either in a written statement, in a medical record, or in a recorded statement, or in all three. And that will be used against that injured worker throughout their claim.
So why is that, that first day so important, Jason, in the workers' compensation case? And how early can decisions affect the claim later on?
Part of the reason it's very important is, as Viral was alluding to, is to really make your employer aware of the incident. One of the mistakes that I run into a lot of times with injured workers is the belief that, maybe the accident or injury that they've suffered is not that significant. So they, instead of reporting it to their supervisor or to HR, they'll say, well, maybe it'll get better, overnight or over the weekend, and try to sort of push through that. So I would caution anyone who suffers an incident on the job that results in an accident, even if they feel the accident or the injury may not be that significant, still report it to HR, tell your supervisor, make sure there's some documentation that the incident occurred in the event that it does become something more significant than they believe. So there's a good paper trail, so to speak.
Mm. So right after an accident, what should an injured worker, prioritize first? Getting that medical treatment, notifying their employer, or documenting what happened?
Well, of course, Evan, no two cases are alike, right? So if it's a catastrophic injury or very a severe accident, get treatment. Safety first. Make sure you get the treatment you need to the best of your ability. Describe to the doctor how you were injured. Also, again, to the best of your ability, mention every body part that you think is hurt because that can sometimes come up later in cases where an injured worker, rightfully so, tends to prioritize maybe the most significant injury. They talk about their right shoulder because that might be the body part they fell and landed on, but they may have also injured their back or hip or something. And if you start mentioning those other injuries a few months later, there may be causation issues where the insurance company doesn't approve those additional body parts. So try your best to document all the injuries and how it happened. Now, of course, some employers, and I've seen clients tell me this, that their employer makes them complete a written statement first before they'll authorize treatment. That's a little bit tricky. If you're catastrophically hurt, my recommendation would be get treatment. But if you're able to complete that statement, do so. You certainly don't want to be argumentative with your employer or give them any reason to doubt your credibility or the credibility of the accident. So certainly fill that report out if it's absolutely mandatory. If it's not, it may be a good idea, like I said in an earlier answer, to try to speak to a lawyer first because that written report can be used against an injured worker uh, if it doesn't sufficiently describe an injury by accident.
Mm. A lot of workers try to push through an injury or, wait to see if it gets better. What problems can, that create both medically and in a workers' compensation claim?
Well, a lot of times, if you have someone who's injured, say on a Friday afternoon, uh, and they do have a tendency to say, well, I'm going to be off for the weekend. Let me see if this gets better. They go home for the weekend. Maybe it improves a little bit. Maybe it doesn't. But when they come back to work on Monday, they're reporting an incident that happened 2 days ago with that intervening 2 days. It gives the employer reason to suspect that perhaps they were injured over the weekend as opposed to at work. So you want to give the employer notice as quickly as possible. So there's no question that the incident, where it occurred, when it occurred, part of the reporting guidelines in North Carolina require you to not only list the date on which the accident occurred, but also the time. Oftentimes, when employees called us after they've suffered an on-the-job accident, especially if several weeks or maybe even months have gone by, they have a difficult time not only remembering the day on which it occurred, but also the specific time. So the more detail you provide early on, the more likely it is that your claim will ultimately be accepted.
Mm. What about this, Vera? When reporting an injury to an employer or supervisor, what information matters most? What kind of statements tend to cause issues later?
So the information you want to give, you really want to give a clear and comprehensive description of how your accident happened. Don't just say I was lifting a box and my shoulder started hurting. That will be used against you to deny your case. You need to go into detail about what was unique about that box. Did it slip out of your hand? Was it uh, heavier than boxes you normally carry? Is it a box that you normally have a helper to help you carry that box, but that person was absent that day and you're trying to carry this extremely heavy box by yourself? So that was an unusual circumstance. You really want to get into details. A lot of times our clients come to us just giving a vague answer, or they're afraid maybe that if they said they were doing something unusual that they may be disciplined for that. So they just say, I was doing my regular job. I was lifting a box. That is an insurance company's dream. They're going to use that to deny your case. So you really want to give detailed statements. This kind of statements that can cause issues later, Evan, are those vague statements, either, like I said, in a recorded statement in an incident report or to a medical provider that simply just says, I was at work and my right shoulder started hurting. That is not sufficient in North Carolina to have a compensable claim.
And Jason, to that point, though, how important is documentation in those early hours? What types of evidence should workers try to preserve if they're able to do so?
Well, as Vera was saying, you really want to show that your injury occurred as a result of an accident. And that's a little bit of a unique twist of the law for North Carolina. Many folks that call us and ask for our advice or seek to hire us as attorneys assume that if they're injured on the job, then workers' compensation will cover them. But in North Carolina, we have an added sort of wrinkle that the injury actually has to occur as a result of an accident, which is defined as an untoward or unlooked for event. Oftentimes, like Viral said, workers are afraid that if they tell their employer that there was something unique or they were doing something different that they may not normally do, that it could lead to a disciplinary type situation. But in fact, that would help bolster your claim. So you really want to figure out, like, well, why on this particular date and this particular time did doing my job cause me to suffer this injury? Whether it was, a wet spot on the floor caused me to slip, or if a machine malfunctioned and, a safety feature was not working and it caused me to suffer an accident. Really make sure your employer knows not only that you suffered an injury, but also the circumstances that led up to the incident that caused the injury.
Say one thing, Evan, with camera phones and things, oftentimes workers are able to take photos of a malfunctioning machine or of an obstacle that was in the way of their forklift that caused them to have an accident. So, certainly photos, witnesses, that's additional evidence to try to preserve after an accident if you're safely able to do so.
Yeah, speaking of that kind of the evolution of things, like the smartphones, I know social media has probably been a big thing though. So how can social media activity, shortly after an accident end up being used against an injured worker in a workers' compensation case?
It is important to know, Evan, or for injured workers to know, Evan, that insurance companies will check your social media. Insurance companies have very deep pockets. They will spend money. They will hire third-party investigators who will conduct surveillance, and that includes a social media search and possibly even following around an injured worker for a few days to see what they're up to, in their free time. So be very careful about social media activity. Change your settings to private. Uh, it's where only maybe your friends and family can see it, or and no one else. Because I have seen social media used against my clients. For example, if you were telling a doctor, you can't lift 5 pounds, and you are posting uh, videos and pictures on social media of you lifting your, 30-pound child and working out, and same thing if you, have a leg injury and you're saying you can't be on your feet for more than a few minutes at a time, and you are posting pictures of you in Vegas partying. These are things that will definitely be used against you. So be very, very careful about social media activity.
Mm. And to close things out, Jason, at what point does speaking with a workers' compensation attorney becomes especially important in the process, and what challenges become harder to fix if someone waits a little too long?
A lot of that depends on how the employer and the insurance company handle the case. There are certain cases where the accident is pretty obvious and the injury is pretty obvious. In those cases, the insurance company is more likely going to accept the claim from the beginning. They're going to send the employee to medical treatment. They may need to go to the emergency room from the workplace itself. So there's no question. In North Carolina, in accepted workers' compensation cases, the insurance company has the right to direct the employee's medical treatment. So they will send them to the doctors that they want them to go see, and they will begin paying temporary total disability benefits once they're out of work for more than 7 days. But in cases where there's an issue as to either the significance of the injury or whether or not the accident occurred at work, Oftentimes, insurance companies, as part of their investigation, are going to ask the employee to do a recorded statement. The insurance adjuster will tell the employee, it's just routine. It's just part of our investigation. We just want to ask you a few questions. It's very important for the injured worker to understand and have an attorney present, if at all possible, um, just so that they can properly describe the incident and the accident which led to the injury. Because really, what they're looking for in those recorded statements is for the injured worker to say things like, "Well, I was just doing my job as normally the way I always do it. Nothing really unusual happened that day. I just, all of a sudden my back started hurting." Uh, and once you sort of say those words, normal and routine and doing things the way I usually did them, that's going to give the insurance company a reasonable basis to deny your claim. So you definitely want to consult with an attorney if it appears that the insurance company or the employer has some question about whether your injuries arose on the job. Um, but even in an accepted claim, the process of going through medical treatment, getting to what's called maximum medical improvement and resolving your claim, the insurance company is never going to help the employee kind of maximize the compensation or settlement that they might receive. So I would say it's better for the injured worker to get an attorney involved early on in the process rather than waiting until near the end or even after a settlement offer has come from the insurance company.
Amazing. Gentlemen, thank you so much for your time.
Thanks, Evan.
Thanks, Evan.
That wraps up today's episode of the North Carolina Injury Rights Podcast. If you've been injured on the job in North Carolina and want to learn more about your rights under the workers' compensation system, you can visit metamcconnell.com to find additional resources and information about working with attorneys Viral Mehta and Jason McConnell. Thank you for listening, and don't forget to subscribe, leave a review, and share this episode so more injured workers can get their clear, reliable information when they need it. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.